Ma'am, put the phone down. I have the right to record. I'm not interfering. Give me that phone. Give it to me now.
That's real body cam audio from a traffic stop that ended up in front of a judge. And by the time you finish this video, you'll know exactly why. That officer's decision to grab the phone cost the prosecution their entire case. And the 3 words that kept this woman from being convicted of anything. And a judge just threw out that arrest, suppressed every piece of evidence that came after the phone was taken. The whole thing collapsed, not because the driver had some secret legal magic, but because she calmly said one sentence that is honestly legal. Gold. And that sentence is not, "I do not consent to a search." It's built on a completely different constitutional, right? The one that a lot of people don't even know they have outside of a protest. The right to record the police. I want to rewind this stop and walk you through it. From the first moment, the blue lights that hit the rearview mirror, because everything the officer did wrong is right there on the body cam, and everything the driver did right is something you can copy word for word. It's around 9:30 at night. The body cam timestamp reads 21:34:12. A patrol officer pulls over a silver sedan for a burned-out license plate light. That's it. No speeding, no erratic driving. On the footage, you can see the officer walking up to the driver's side window, flashlight in hand. The driver is a woman in her mid-30s. Well, call her Sarah for this story. Sarah has her phone in a dashboard mount. But the moment she sees the officer approaching, she takes the phone out and holds it steady in her left hand. Lens pointed toward the driver's window. It's clearly recording the officer leans in license and registration, ma'am. Sarah doesn't argue. She hands over her license with her right hand while keeping the phone recording in her left. And that's when the tone shifts. The officer glances at the phone and says exactly what you heard a moment ago. Ma'am, put the phone down. Now, pay close attention to what Sarah says next. She doesn't scream about her rights. She doesn't shove the phone in his face. She says calmly, "I have the right to record. I'm not interfering." Those 3 words matter more than most people realize. Because in that moment, Sarah is drawing a legal line. She's asserting her First Amendment right, but she's also making clear that she is not obstructing. She's not resisting. She's not delaying the stop. She's just recording. And the First Amendment, as it turns out, protects exactly that the First Circuit Court of Appeals said it plainly in Glik versus Cunniffe back in 2011. There is a clearly established constitutional right to record police officers performing their duties in public. That case involved a man who used his cell phone to record officers arresting someone on Boston Common. He was arrested for wiretapping and disturbing the peace. The court threw it all out, ruling that the First Amendment protects the filming of government officials in public spaces, subject to reasonable time, place, and manner restrictions. Recording a traffic stop from inside your own car, without stepping out, without shouting, without blocking the officer's movements, that falls well within those reasonable limits. And this isn't just a First Circuit thing. The 11th Circuit held, in Smith versus City of Cumming, that citizens have a First Amendment right to photograph or videotape police conduct. The 3rd Circuit, in Fields versus City of Philadelphia, confirmed that recording police is protected and that the right extends to both the act of recording and the act of keeping the recording. So Sarah, sitting in her car holding a phone steady, is standing on a mountain of federal precedent. But the officer on the scene that night either didn't know that law or didn't care. You can see him on the body cam take a half step back, then suddenly reach through the window. The footage shakes violently. The audio catches the officer saying, "Give me that phone. Give it to me now." You hear Sarah say, "No, I'm not." And then a brief struggle. The phone clatters. The timestamp hits 21:35:02 in less than 50 seconds. A traffic stop over a license plate light has just turned into a physical seizure of private property and an arrest for obstruction of justice. Let's pause right there, because that moment, The grab is where the Fourth Amendment detonates under the officer's feet. The Fourth Amendment protects people, not just places, from unreasonable searches and seizures. A seizure of property occurs the instant an officer meaningfully interferes with your possessory interest in that property. That's United States v. Jacobson, a Supreme Court case that defines the line. The second that officer wrapped his hand around Sarah's phone and yanked it out of her grasp, he performed a warrantless seizure, and a seizure of personal property requires either a warrant or an exception to the warrant requirement that fits the circumstances. There's no exigency here. The phone wasn't a weapon. The driver wasn't deleting evidence. She was just recording. So why did the officer think he could take it? Many officers mistakenly believe that if they order you to stop recording and you don't comply, that alone gives them the authority to seize the device. It doesn't. Refusing to hand over your phone while lawfully recording is not obstruction. And it certainly is not consent to a seizure. Here's where the judge's ruling came in. At the suppression hearing, Sarah's attorney argued that the officer violated her First Amendment rights by interfering with her protected recording and independently violated her Fourth Amendment rights by seizing her phone without a warrant, probable cause, or valid consent. And because the arrest for obstruction flowed directly from that unlawful seizure, there was no probable cause. The officer claimed she resisted when she tried to hold onto her own property. There was no legitimate probable cause for the arrest. The judge agreed the phone seizure was unconstitutional. Everything that came after it, including the arrest, the search of the phone that happened later at the station, and all the statements Sarah made while being handcuffed, was fruit of the poisonous tree. Suppressed, gone, case dismissed. Now there's a second legal layer that the judge touched on, and it's one you need to understand if you ever find yourself in Sarah's seat. It's the difference between a lawful order and a lawful order. Sounds redundant, but hear me out. An officer can give you a command during a stop. Stay in the car, put your hands on the wheel, and those are generally lawful orders tied to officer safety. But an order to stop recording is different. The courts have been incredibly clear. Unless the recording is genuinely physically interfering with the officer's ability to do their job. I mean, blocking their hands, shining a blinding light in their face, or ignoring repeated safety commands. The act of recording itself does not automatically become a crime, simply because the officer doesn't like it. In Glik v. Begin, the First Circuit specifically addressed a traffic stop where an officer told a woman to stop recording. The court held that the right to record a traffic stop was clearly established, and that an officer cannot order a citizen to stop recording without a legitimate, articulable reason beyond mere annoyance. So if an officer tells you put the phone down, and you calmly respond, I have the right to record. I'm not interfering. You are not disobeying a lawful order. In the criminal sense, you're disagreeing with an unlawful one, and you're doing it in the exact manner the Constitution protects. Of course, this story could have gone a completely different direction if Karina had said something else. If she had shouted, if she had pulled the phone back aggressively, if she had opened her car door, and then you'd be watching a very different video. And the judge's ruling would have been a lot less certain. That's why the exact words you choose are not just a legal formality, they become the frame that the body cam footage is later judged through. And in this case, I'm not interfering is what defeated the obstruction charge. The officer couldn't credibly claim she was physically impeding him. When the video showed her sitting, still holding a phone, and doing nothing except calmly speaking, the words and the video matched. That's a legal lock. So let's pull out the practical use it tomorrow guidance. If you're ever in a situation where you're lawfully recording the police and an officer demands that you stop, here's the script. You don't have to recite case law and you don't have to get into a debate. You say this loud enough for your own recording to capture it, and calm enough that it doesn't escalate things. I have the right to record. I'm not interfering. That's it. You're not consenting to them taking your phone. You're not handing it over. You're not saying, come and get it. You are simply asserting your First Amendment right and simultaneously laying down a factual marker that you are not obstructing, that if the officer then chooses to grab your phone anyway, and you see that hand coming through the window, I need you to remember this. Do not physically fight. Let the phone go if it becomes a safety issue. Because the moment the officer seizes it without a warrant or a valid exception, the legal violation is complete and your remedy is in court, not on the side of the road. Your new job becomes documentation. Note the officer's name and badge number. Note the exact time. And if there are witnesses, get their information. The phone itself just became Exhibit A in a motion to suppress. I also want to address a nuance that often trips people up. Some officers will pivot and say, "You're under arrest for obstruction," solely because you didn't comply with the order to stop recording. And you might think, well, they can't do that because the order was unlawful. You're right. You're right in the long run. But on the street, an officer can still physically arrest you. What matters later is whether there was probable cause for that arrest. And the Supreme Court has made it clear in Nieves v. Bartlett that the existence of probable cause generally defeats a retaliatory arrest claim unless the plaintiff can show that similarly situated individuals who did not engage in protected speech were not arrested. That's a high bar. But here's the critical detail. If the only basis for the obstruction charge is your refusal to stop lawfully recording, courts have repeatedly found that there is no probable cause for that arrest because the underlying order was not a lawful one. So while you might spend a few hours in a holding cell, the long-term legal weight is on your side. And that's exactly how Sarah's case collapsed at the very first evidentiary hearing. The judge didn't even need to get to the retaliatory arrest argument because the seizure itself was patently unconstitutional. That brings us to one more piece of the puzzle. What happens when the officer not only takes your phone, but then starts swiping through it? That right, there is a search, not just a seizure. And a search of a cell phone generally requires a warrant, per Riley v. California. Sarah's case didn't get that far because the phone was suppressed before they could use anything from it. But in another version of this story, an officer who unlocks the phone without a warrant is digging an even deeper constitutional hole. I'll save that full breakdown for another video because the warrant requirement for digital searches deserves its own deep dive. For now, I want you to leave with a shift in mindset. A lot of people think their only legal tool during a stop is, I do not consent to a search. And yes, that's important, but it's one tool. What Sarah's case shows is that the right to record is equally powerful. And in many ways, it serves a dual purpose. It protects your ability to document the encounter, and it simultaneously forces the officer's behavior into a framework where their actions are being contemporaneously preserved. That doesn't just help you later in court, and it can change how the stop unfolds in real time. The camera, plus the calm assertion of your right. This can be a de-escalation tool in itself, provided you don't cross the line from recording into interfering. One final note on something I see people get wrong online. You do not need to inform an officer that you are recording in a two-party consent state if you are recording openly in public, where there is no reasonable expectation of privacy. A traffic stop on a public road is not a private conversation. The majority of federal courts have treated open recording of police the same way. But if you are in a state with specific laws about audio recording of private conversations, and you're in a situation where there might be a nuanced privacy interest, it's always worth knowing your local statute. For the typical traffic stop, though, holding up your phone in plain view is not wiretapping. The Glik court made that abundantly clear. So next time you see a body cam clip of an officer grabbing a phone, you'll know what's actually happening underneath the surface. A collision of First Amendment protections, Fourth Amendment limits on seizures, and a single sentence that can flip the entire case. I have the right to record. I'm not interfering. Learn it. Say it calmly. And let the body cam do the rest. But what happens when an officer doesn't just grab your phone? They unlock it and start scrolling through your messages. Right there on the shoulder of the road, that crosses into a completely different chamber of the Fourth Amendment. One that the Supreme Court has drawn a bright line around in the last decade. And I think you'll be surprised by how little room there is for officer discretion once that line is crossed. I'll walk you through that one next time.